Hello everyone, hope you're doing well. Welcome to Chapter 5, the Physician-Patient Relationship. I really enjoy doing this lecture because it talks about the legal binding agreement patients have with their care providers. And this is not just with physicians, it can be with APCs, other healthcare providers in a healthcare space. And then also for your background, there are a lot of instances in this module where you'll see similarities in your future career. So pay attention, take a look, and I'll share a few stories along the way. All right. One thing that you have to know in order to start out this important chapter is the fact that a patient and a clinician agree to form a relationship, and they do have a contract for services, even though it's not in a written agreement a lot of times. When a physician takes on a patient, they agree to assume their care. And some of the rules and regulations around that is you have to provide care that is reasonable. And also, if you discharge a patient, you have to let them know within a time frame that's reasonable as well. For many organizations, that's 90 days, and you have to have a plan to continue their care after the discharge period for a certain amount of time. Like I said, 90 days. You don't have to do it indefinitely by any means. Now, this slide also says patients or physicians can select, or it really should say providers because you have APCs here too, but they can select their patients. Yes, that is true in the variety of a sense, but like that's true for physicians and organizations that are private in relation to the funding they get. If you get funding from Medicare and Medicaid, or you're a not-for-profit, you can't pick and choose your patients. So, some organizations can turn patients away, many cannot. As an example, not-for-profit organizations cannot turn patients away that they're not willing to see. Mainly, of course, surrounding payer mix, right? And payer mix is their insurance. Okay, quick note there. All right, physicians do have rights, though. They may state the services they're going to provide, which is in the best interest of the patient. They're not here just to write prescriptions for drugs, as an example. They have the right, of course, to expect payment for services, and that's a standard, right? And then they have the right to take vacations and time off, but it's legally prudent that they arrange coverage when they do so, right? If something happens to their patient when they're gone, there could be a negligence claim, and they don't want that to happen. Okay, they're not on 24/7, although some of them are on quite a bit, and some of them choose a life that's really challenging. That's why you have to have partners, usually in private practice, in order to balance out your your needs, right? You have to be professionally competent if you're going to be a provider. And there's a lot of laws, like anti-kickback laws, that protect referral sources. So you can't prescribe something to a patient, as an example, a med that you're going to get a kickback from in order to prescribe. It has to be in the best interest of the patient. So, that's one thing that's really cracked down over the years is insurance, not insurance, but prescription coverage, right? So if a patient, as it comes in, has a problem with weight gaining or weight issues, a provider can't just prescribe a drug because a company wants him to, and maybe he gets something in return. I'll give you an example. I had a colleague that I knew in Alabama. It's not really a colleague, I guess it's more of an acquaintance. And he would have drug reps come into his office all the time, and they would give him a lot of stuff. And that was kind of the standard 20 to 30 years ago. Well, longer than that, actually, 30, 40 years ago. And there was physicians that would get cars, expensive trips. They would get all kinds of different stuff. But there's laws and regulations that protect patients now because there's studies that found that these providers were prescribing based on the fact they got free things, right, instead of what was best for the patient. One thing I'll mention, I put APTA as an example. For PTs, they have an organization that gives them oversight, but the AART, I know you guys have seen this before, but this is just a Google slide here. AI is everywhere now, just as an example. But there's ethics requirements for radiography techs, and the AART is the oversight for that. It's just something I wanted to share, and I'm sure you're very, very aware of that, all right? Same thing for physicians with the AMA. AMA, medical ethics standards, human dignity, honesty, responsibility to society, confidentiality. One that I really appreciate is freedom of choice. And I put an example here again about PTA, Guide to Ethical Conduct. You guys don't need to take a look at that, but there is a Guide to Ethical Conduct with the AART as well. Some professional practice responsibilities that physicians have on top of what challenges they encounter on a daily basis. This adds a layer of complexity. And it's a lot of stress, right? This is one of the reasons I think physicians, burn out really, really easily because, they have a duty to do a variety of different things. I'm not going to read through this, but, as an example, physician's creed is do no harm, right? But also, a physician or a provider sees someone ailing, as an example, just in public, they have a duty to provide medical care to treat that patient no matter the circumstance. So, I hear a lot of providers at a given time, really struggle with the day-to-day responsibility and the weight they have on their shoulders. So just keep that in mind. It's not an easy job. Physician cannot legally or ethically turn away a patient in an emergency, and I just talked about that a little bit. Another example of this, when I worked in Alaska, I had a critical access hospital, and we had patients, show up in an emergent state all the time. And regardless of payer, since we're a critical access not-for-profit hospital, we had to see those patients. And I'm not just specifically talking about the emergency room. We had repeat offenders, as you could say, in the emergency room quite often. And we had a legal responsibility to treat those patients. And even though we knew when they came in, there potentially wasn't an issue, we had to treat them each time, understanding that there was an issue. So, that can be challenging for a provider to see the same patient come in to their practice over and over, and, maybe they're just drug seeking or need prescriptions, as an example, that are not in their best interest. The provider has to do a workup and understand, especially in the emergency setting, because what if a patient does come in and they do have an issue and we don't treat it? You can't ethically or legally turn a patient away in an emergency. And that's why EMTALA is there to protect the emergency room staff and patients, to make sure and ensure that you do a medical screening exam. And that's for the emergency room. People in need, you can't have patient dumping. You can't just throw a patient away because they're challenging. You can't turn away a patient from a hospital because they're uninsured, as an example. And there's a federal offense to dump a patient from one facility to another. Although I will say, it's hard to define, but you do see this happening. That's why there is a law. It's hard to define, but it does happen at times, and it's really sad because people are in need. And I don't think it's, healthcare organizations doing things for bad reasons, but staffing continues to be a challenge in healthcare today, and maybe that's a part of it. Physicians do have the right to choose a patient, but can't drop a patient once they agree to treat that patient. However, this depends on the organization. If it's a not-for-profit and it has certain federal guidelines surrounding funding, you can't choose a patient from the perspective of payer, right? There has to be guidelines. So you can't choose. I'm trying to phrase this in a way you understand. You can choose based on guidelines. So if you have a payer mix guideline that follows the community health needs assessment, as an example, and you take a certain percentage of this insurance, certain percentage of this insurance, certain percentage of this insurance, you have to take all insurances as not-for-profit, but you have to allocate it in a way that's understandable. So if someone does complain and legal instance happens, so legal challenge happens, you have a way to explain what you were doing. All right. Can't abandon a patient. We talked about this already. It can be a civil breach of contract or negligence. You have a duty to treat patients who have AIDS, right? This is something that happened many years ago, this law. So you can't just turn away a patient because they're in need regarding AIDS. This is just a specific example. There's other examples as well. You have a duty to properly identify patients. You have to remember HIPAA, but You have to understand when you treat a patient, and before you treat a patient, to know that that's the actual patient you should be treating. One thing I'll mention in regards to this before I move on to the next slide, there's a lot of stories, you can look it up, where surgeons has operated on a patient, the wrong patient as an example, maybe took off, not just like taking off the wrong leg. I've heard of that before from a surgeon perspective. That would be negligence, right? It's the right patient, the wrong surgery. But I've heard about patients that would go in for a certain procedure and come out with a surgical procedure that they didn't intend to happen because they did surgery on a different person, and that's just not properly identifying the patient. It's the surgeon's fault. It's the tech's fault that was in there. It's whoever registered the patient. And there's been huge claims, huge lawsuits, and huge settlements regarding patients who've been treated poorly because they weren't identified properly. So just keep that in mind. Get a duty to tell the truth. The provider has to tell the truth even if it's difficult, right? Unless there's a mental health reason why they would not. But you have to tell the truth. If a patient has cancer, you have to tell them they have cancer. You have to give them their life expectancy. All that kind of stuff is essential in healthcare. Patients do have rights. A patient does have a right to confidentiality and HIPAA. Privilege of communication, right? You hear about that all the time. Be careful with HIPAA, especially when you're digging into patient charts that you're not supposed to be in. People take that very seriously. And I've had to terminate quite a bit of employees for getting in a chart wrong, even if on accident. So be really, really careful with electronic health records in relation to that. And I just want to give you that word of thought, word of wisdom, as you might say. Be careful with patient charts. HIPAA is a real thing, and organizations take it very, very seriously. All right. Patients can also have living wills, durable power of attorney for healthcare, and a DNR order. And I know all of you are aware of those things. Minors do have rights, right? In most states, minors or anyone under 18. Minors can be seen in our state as an example for mental health reasons, sexual health reasons, and there's certain things where a parent does not have to consent to medical care. So there's an actual website I can share related to this if you're interested, so just reach out. There are certain treatments that people under 18 can request without parental guidance in this state, and it varies from state to state, so there's differences. The patient's responsibilities, consent is a big thing, right? You have to consent to treatment. You can choose whether or not you have treatment. So if you have a deadly disease and you don't want to treat it, that's your right and your consent. You consent to that treatment whether or not you want it. And there's a formed implied consent. We've talked about implied consent. Walking into a lab draw. This is just an example. I'm not sure if it would stand in legal court, but like in a legal battle in a court proceeding. But if a patient walks in and pulls up their sleeve to get their blood drawn, as an example, that could be implied consent. And that's the basic one I can think about. Informed consent, right? When you inform the provider that that's the direction you want to go. A lot of times the consent happens through written documentation. Informed consent is when a patient agrees to treatment after being told the advantages, the risks, alternate treatments, and potential outcomes. So that's informed consent. Usually it's signing, right, when there's surgical procedures. Implied consent, one thing I'll mention that's really important in a medical emergency, if a good Samaritan, a provider, goes to take care of you in that situation, a provider, I'm trying to say like a physician because that's what we're talking about in this lecture, but a physician says in a medical emergency, they go and take care of you, save your life, that's implied consent because if they didn't, there would be adverse effects. So that's just another example of implied consent. Probably a better one than the lab draw example that I gave earlier. But these exceptions when you have time, there's also refusals to grant consent, something you could take a look at. We're not going to talk about Terry Schiavo because we're at the end here. But if you have any questions, reach out. This is a great chapter. Thanks so much.